which which looks into the viability, feasibility, and commercial aspects of a resolution plan to approve the resolution plan, subject to such approval by CCI, which may be obtained prior to approval of the plan by the NCLT under Section 31 of the Code. So the minority view takes note of the position adopted by NCLT that these are not mandatory requirements but directory. Question as to whether a requirement under the statute is mandatory or directory depends upon the intent of legislature and not upon the language in which the intent is blocked. The meaning and intention of the legislature must govern, and these are to be ascertained not only from the phraseology of the provision, but also by considering its nature, its design, and the consequences which would follow from construing it one way or the other. The use of the word shall raises a presumption that the particular provision is imperative. However, the prima facie inference about the provision being imperative may be rebutted by other considerations, such as the object, scope of the enactment, and the consequences flowing from such construction. The interpretation of the word shall as directory has been a purposive effort to the court to sustain the object of the statute and at the same time ensure compliance with the requirements. This court has interpreted shall as directory to preserve the legislative effort and intent of the statute. So the minority view tries to reason out that in some cases the word shall has been used as directory in nature also. And given the intent of the legislature, even this one should be relaxed. Further held that IBC and Competition Act have timelines for the discharge of a duty and function. In this light, it is impermissible to interpret the provisions in one enactment by keeping in perspective the starting point of a timeline and the termination of a timeline in the other enactment. The enactments are allowed to work parallelly and without pressure for performance from the other in line with the duties and obligations passed through the enactments. So, the conclusion of this case is that by 2:1 majority, it has been held that the proviso to Section 31, subsection 4 of the code mandates prior CCI approval before any resolution plan involving a combination is voted on by the Committee of Writers. The Supreme Court has also emphasized that this mandatory requirement ensures competition concerns are addressed upfront. So, requirement of dealing with prior approval of Competition Commission, they should be addressed upfront, avoiding any incongruous situation where a COC approved plan is later rejected by the CCI and rendering the entire CIP process futile. So this landmark ruling also reinforces strict adherence to statutory timelines under the IBC and the Competition Act, balancing swift insolvency resolution with robust regulatory oversight. So this is a conclusion of our very first case. In case of anyone has any question relating to this particular case law, if anyone wants to say something.
No, this is interesting because in other matters, the timelines proposed in the IBC have been adjudged as directory rather than mandatory.
Correct.
How come this is mandatory and not directory?
Yes, and even NCLT earlier. That's why I've given the minority opinion also, because earlier even the NCLT was adopting this approach that and upheld by the Supreme Court that this requirement is directory in nature. But then now Supreme Court has clarified that as far as the rule of competition, combination of companies, the proviso, because proviso is, they are making an interpretation that since there is a specific proviso in such cases, mandating prior competition CCI approval before the resolution plan is put to vote. So that needs to be strictly adhered to given the legislative intent. Otherwise, there was no need for a proviso also. So, but yes, an interesting development.
Don't you think that COC and RP and legal advisors, okay, who were there, they should have been extra careful in particular to this case, because as you yourself have mentioned in the beginning, this was the largest or second largest player. Okay. We have
Yes.
other companies where their market share is not significant. Okay. Whether it is steel, textile, other companies, their share, or cement companies, in fact. Okay. So their share may be few percent, but here we were talking of percentage share of the market, which was above 25-30%, and we had the competitors also bidding. So don't you think the legal counsels, etc., they should have advised the COC and RP uh, uh, to be cautious in that respect? Finally, interpretation is done by the courts, but don't you think the legal counsel should have been should have made the cautious advice to COC and RP?
Yeah, I think, must have been the case that INSCO must have been writing to RP from the beginning in this case. That please don't bring forth the AGI Green Pack's resolution plan before COC before they take the CCI's approval. As INSCO has been fighting it throughout and ultimately succeeded before the Supreme Court. So definitely RP must have taken some advice, but maybe the law was on the side of RP at that time because NCLAT had already relaxed that requirement under the proviso. Supreme Court has also upheld before prior NCLAT's verdict, but now Supreme Court takes a different stand. So I believe personally that perhaps the law was not settled to that extent. So maybe, I mean, this is a new development in law. It's not as if the proviso definitely existed prior to the judgments, but since the judgments had already relaxed this requirement. So I don't know. There's nothing mentioned in the Supreme Court judgment that how the council advised, especially these are privileged things.
So
So
that
I
as
don't know. I know,
sorry to
but
I'm
but
as
what I see is that
RP.
NCLT had already, in such matters, given relaxation that this requirement of taking prior approval of CCI before putting the resolution plan to vote before the COC should be directory and not mandatory. So NCLAT has they've taken a stand. So maybe perhaps based on those judgments, RP might have been advised not to really harp upon or insist on CCI's approval prior to putting the resolution plan to vote before the COC.
Everything is it's not only the law, but the facts also has to be seen.
But
Uh,
even I would say RP also had in this case granted relaxation to the RA. Yeah. So because in fact it is coming that RP himself had granted the relaxation. So ultimately, whatever advice perhaps is taken, ultimately the call is of the RP. I mean, he can't even blame the other professionals from whom he's taking the advice because RP, whatever action is taken by the RP, he's solely responsible for it. But yes, that is true. That ultimately, because of this requirement, that relaxation should not be there. So ultimately, that uncertainty in the COC, in the CIRP process, because while AGI Green Pack was going to be was all set to take over this company, but then ultimately it is the INSCO who is the second resolution applicant, perhaps, who is benefited from it. But if you really look at the statute, statute is very clear that there is a specific proviso carved out for this. So even while enacting IBC, the legislature has already applied its mind. And while other requirements are relaxed, that after the NCLT's approval, you take 1 year to take approvals. But as far as Competition Commission is concerned, they have mandated prior approval. Of course,
you have
RP
one
should
more.
have. Yeah.
Sorry, there's one more, non-legal point of view if you take. See, when we are talking about resolution in a economics sense, talking as an economist, consolidation of an industry by definition means there is certain capacities being consolidated with one market participant or a market leader or something. So number of participants goes down. So capacity with one participant increases. Now, if you are talking about Indian capacities in the global context, the discrepancy is so huge, and there is so much scope for Indian industry to grow from a capacity standpoint that taking such a view can also possibly amount to taking a very small view of things. And of course, not to ignore the market distortion effects that such consolidation can bring. I mean, we can see that in industries as well. But that is something that, I mean, to a certain extent, if the RP, as you rightly said, ultimately it comes down to the RP. He has also at one level been courageous to accede to this kind of a request.
Correct. But I personally feel
But
that.
yeah, I mean, interpreting the code, Supreme Court ne jo, he has been correct. If there's a specific proviso, then it is mandatory.
Right. Yeah, I agree with Anish. Recently, in the case of, there is a proviso in regulation that asset-wise sale can be done during CRP process. In JP case, because they started in the first go itself, and that was ruled out by the NCLT. No, it cannot be done. So then modification was made. So I think those are something like proviso and all. Those are all are mandatory. As we see now clearly, so it cannot be taken that in a light manner. These have to be adhered to.
Right.
But I would also agree. I mean, with Nanavati ji, that RP was courageous enough to grant this relaxation, but he was also supported by NCLAT judgments that have been mentioned in the minority view also. So because of the change of legal position, maybe how it was argued before Supreme Court. But I can also see in the facts, I've also mentioned that ultimately this relaxation, whatever it is, ultimately the requirements of CCI approval, it was granted within 132 days of whenever it was applied. If you see in paragraph 98, so under the combination regulations, this relaxation was granted by CCI. But even then, the Supreme Court has made an observation that since the CCI was not approached prior to the COC, prior to the resolution plan being put before COC for approval. So there is a violation of the proviso under section 21. So I believe it's a bit harsh on the resolution applicant here, since he has already obtained CCI's approval, but perhaps maybe the intent was to observe strict compliance of the regulations. So this is how it is.
Yeah.
No, we can see that in the claim acceptance timeline also. Okay, earlier it was kind of flexible, but then you said no, not only 90 days and that kind of thing. So
correct.
law also evolved.
Claim acceptance now, because till RFRP you can do it. I mean, the RP can do it.
So there has always been timelines have shifted one way and the other. Yes.
I know, but in many CRP, I'm still saying that RPs are still following 90-day rule and saying go to court. But yes, at least IBBI relaxed it to some extent. It's for the RPs to do. So that is how it is.
So even in the under liquidation also, even though timeline is 30 days, but yes, that kind of flexibility is not available, is not there with the liquidator to accept delayed one. But mostly, if someone is approaching NCLT for condoning the delay, they are accepting.
Yeah, they are accepting. That's true. They are accepting. before the liquidation, before the assets are liquidated and distributed, if somebody approaches that my claim was filed later, they're accepting it immediately.
Yeah, mostly. I at least I
They
have
are
not
there.
seen any rejection which
They are because it's a
which has
legitimate
been
claim,
done.
and they are only accepting continuation. Ultimately, it is for the liquidator to adjudicate on those claims. So they are not actually doing something on merits. They are only relaxing the requirement of filing the claim in a prior point of time. So they are just condoling the delay in filing of that claim. Ultimately, it is the liquidator who has to adjudicate.
Satish ji, लेकिन our claim to a liquidator was rejected on account of timeline. Though, and we observe that NCLTs are partial towards statutory authorities in respect of relaxation of timelines rather than
Correct.
other.
If it is IT, GST, they specifically mention public
Yes.
authority.
Correct.
See, there is.
No, ठीक
Can
as
I
long as
can I
NCLT
join?
and
Yes.
Yeah, Shantanu. So my observation is this whole stuff that after 30 days, obviously all the statutory authorities, most of them come back usually after 30 days. Usually after 30 days, and then there are some other workmen and this type of people also come late. Now, I somehow don't understand what is the need for each of them to go to NCLT, pray for condonation of delay, and it simply multiplies my liquidation cost because each IA I have to defend, have a lawyer.
Correct.
I used to actually previously collate all these late claims, kind of adjudicate and file one application myself before NCLT, saying that, boss, these have come late, but these are pretty genuine claims. You kindly allow. It doesn't really change the order of priority or anything of that sort.
Correct.
Then one fine day, NCLT kind of scolded my lawyer, saying ki, why you have to come, they will come. Now 5566 applications, we are just struggling with it. So this is a very bizarre thing, and it just simply multiplies your litigation cost like anything.
Correct. So
So
ultimately,
probably a regulation change is required here, that the liquidator can collate the claims, adjudicate them, and to the extent he is admitting it, just apply to NCLT and do it. If they have to anyway condone the delay, then why every fellow has to go?
And I
You're
agree,
absolutely right.
Mr. Ray. In fact, every time list of stakeholder is revised during liquidation period, same has to be filed with the NCLT.
Absolutely.
And they take into record as IA. So unlike CRP, where it is just it is released list of creditor, during liquidation period, it has to be taken on record, every revised list by NCLT.
Absolutely. So it makes it two applications. One, the fellow goes and mostly, as you said, it is all the tax authorities and the government guys. Now, in one case, there is a huge municipal dues. Ultimately, after a lot of cajoling from our side, the municipality filed the late, but they filed the claim nevertheless. Now I have to tell the municipality, Bhai Sahab, sorry for the disturbance. Then I have to tell the municipality boss, you go to NCLT. So it's very funny actually.
No, you are absolutely right. I think just in consonance with CRP regulations, how they have increased the timeline from 90 days to the date when RFRP is published, request for resolution plan is there. So perhaps somewhere there should be some relaxation that till the assets are liquidated or till the assets are sold. I think
They can always say that if
about-
any distribution has been made prior to the claim being
Yes.
filed, it
Correct.
will not get affected.
Correct. Something like that should be there because these are unnecessary litigations. NCLTs are otherwise also very burdened, given the way they are also. So I believe these are all formal applications. I mean, there is no need for it. I think the liquidator should deal with it at its own end, and ultimately, whenever in periodic reports, he can mention it before NCLT what he has done.
Precisely. Precisely. I don't know because they are only saying, okay, delay condone liquidated to adjudicate. Now I adjudicate and then I modify the list and I file it. Then another claim comes. The other fellow, I tell him, Ki Baba, you also go. How many times to modify? Why don't
Correct.
I
So
why don't I
perhaps that's why.
quarterly collate, adjudicate, and quarterly I file a application before NCLT? It's actually a very irritating provision from a liquidator's point of view. It just simply increases your work
Work.
without uh, any sense actually. Previously,
Without any sense.
Bombay NCLT used to allow it. I was doing it.
Nobody's actually applying its mind while these applications come up. There's no need for such applications
It's
also.
pretty automatic also, but you still have to have a lawyer.
Correct. Correct. Absolutely.
So, and sometimes they keep on adjourning the things also. Simple things they keep on adjourning.
That's why I'm saying the way NCLT is functioning, there's no need for such applications. There is no need. But I believe
Yeah,
when this initial, perhaps that faith with RP, with IP, I think initial apprehension that maybe IP will not report things properly, all those things will come. I think all those apprehensions should recently go. Now the act is almost 9 years old. So I think the needs, I think either the IPA or the IBBI should take it up somewhere. There should be some amendment somewhere in the regulations also. But at least there are many such applications which are filed, which are actually not required to be filed before NCL. All those things can be taken off, taken
even
care of
listen,
by the RP's
even the
report.
progress reports have to be now filed by a way of an IA.
IA with an
Previously, we were
application.
just
I know, correct.
filing the progress report. So now you make a progress report in a particular format, you file an IA on that, it comes up, and they simply say, okay, taken on record.
And that has to be also accompanied by a memo of parties.
Yes, yes.
Correct.
It's like, anyway, ठीक है sir. Okay.
Sir,
Thought I should
have
also
one
give.
query, sir.
Without any other point of discussion on this very first case, I mean, it's competition coming back to the requirement of Competition Act. Yes, ma'am, you want to say something?
Yes, sir. So what is the exact timeline till RP can accept the claim during CIRP?
Yeah, so regulations say that till the RFRP, stage of RFRP.
So not till the resolution plan is put forward at least 7 days prior. I think now it's amended.
Amended, perhaps maybe I'm not updated. What
Okay.
I knew was.
I think, sir, now it can be accepted till the approval of resolution plan prior to
By
the
the
approval of
COC,
resolution.
by the COC.
By the COC,
Right.
by the COC.
Yeah.
Okay.
That
Not
is the
the
latest
RFRP
thing.
stage. Okay.
No.
Okay. All right. Yeah, so as per as Shantanu sir said that even in liquidation process, there should be some amendment. Maybe one needs to find a way out how to make amendment in the liquidation regulations also to that. That can decrease the burden on the liquidator. Anyways, so now we'll deal with the second case. The second case. The other cases are a bit, will take shorter time. Also, not the very first case was having a larger issue, a different issue also. Now this one is April 2025 verdict, Rakesh Manoj versus Gurdas Agro Limited. So this is the 138 NI case. And the respondent here had filed a section 138 NI complaint against the appellant and his family for issuing 4 dishonored checks due to insufficient funds. A legal notice was served, but no payment was made, leading to complaint being taken up by the Judicial Magistrate, First Class of Batinda. During the pendency of the case, the appellant and his wife filed personal insolvency applications under Section 94 of the IBC. Right, both had filed personal insolvency applications. Now, the appellant sought adjournment of 138 proceedings by citing the interim moratorium provisions under Section 96 of IBC And the trial court of JMFC Bathinda, it rejected this application on 23rd May 2022. The appellant challenged the rejection before the High Court under Section 482 CRPC, invoking its inherent powers, and the High Court dismissed this petition on 23rd March 2023. Thereafter, the Supreme Court, we went to the Supreme Court, where the only issue was that whether the interim moratorium triggered by filing a personal insolvency application under Section 94 of the Code and operative under Section 96 can stay criminal proceedings under Section 138 or 141 of the NI Act in check dishonor cases before the criminal courts of judicial magistrate first class. So whether the interim moratorium under the personal insolvency cases can also give relief to the directors who are prosecuted in complaints under Section 138 of the NI Act. Relevant provision, we all know, Section 94 of IBC, where a defer who commits a default, he can file an application before the NCLT. So I will not read the entire provision, as I think everyone knows whose provision is this. And Section 138 of NI Act, it talks about the prosecution in cases of dishonor of checks, where the offence is completed only after 15 days expire after the legal notice is served on the accused. Now, Supreme Court observations in this case on the issue. So we start with the reasoning. Para 11 says it is to be noted that upon the application being admitted under Section 96, the moratorium provisions under the IBC offer protection only to the corporate debtor, that is the company, and do not extend protection against civil liability to personal guarantors by specific exclusion or to any individual who is prosecuted for committing a criminal act. So moratorium provisions, they are offering protection to corporate debtor and do not extend protection against civil liability to personal guarantors. The interim moratorium under Section 96 and moratorium under Section 101 are designed to offer a breathing space to the corporate debtor. However, this moratorium is not intended to shield individuals from personal criminal liabilities arising from their actions outside the scope of corporate debt restructuring. The respective petitioners having filed insolvency applications as personal guarantors cannot extend this protection to avoid prosecution under Section 138 of NI Act. We are of the opinion that the object of moratorium or for that purpose the provision enabling the debtor to approach the tribunal under Section 94 is not to stall criminal prosecution, but to only postpone any civil actions to recover any debt. The deterrent effect of 138 is critical to maintain the trust in the use of negotiable instruments like checks in business dealings. So ultimately, primacy is given to check bouncing cases. They are saying that if such tactics are adopted by the personal guarantors, then there will be no faith in issuance of checks, and then such proceedings will, if they are also stalled, then there will be no faith in the check system. So, negotiable instruments, primacy given to that. Supreme Court also concluded that the interim moratorium under 96 of IBC does not apply to criminal proceedings under 138 of NI Act. The court clarified that insolvency proceedings cannot be used as a shield to avoid criminal liability for check dishonor. This judgment upholds the independent nature of penal provisions under the NI Act and ensures that debtors remain accountable for such offences irrespective of insolvency status. Any point, anyone wants to discuss anything on this? Any participant? There's a lot of litigation under 138 NI Act. And so this is another perspective, especially we all know that corporate debtors moratorium is applicable to them even in 138 proceedings. But as far as directors are concerned, they have been held to be moratorium will not be held to be applicable against them. Shall we move to the next case then?
Yes, please.
Yes. Okay. Now, the third case is it's a March 2025 verdict of Supreme Court, Vishnu Mittal versus Shakti Trading Company. Here, the appellant was a director of corporate debtor, which had appointed the respondent as its super stockist under a business contract. In this capacity, the appellant issued 11 checks to the respondent, which were dishonored upon presentation on 7th July 2018. The respondent issued a legal notice under 138 of the NI Act on 6th August 2018, but the check amounts remained unpaid. Consequently, a criminal code under 138 of an act was filed against the appellant, who is the director of the CD, in September 2018 before the CJ in Chandigarh. While this was ongoing, solvency proceedings were initiated against the corporate debtor under IBC, and a moratorium under Section 14 IBC was imposed on 25th July 2018. IRP was appointed on the same day, and despite the moratorium, the trial court issued summons to the appellant in the Section 158 Act proceedings. The appellant then approached the Punjab and Haryana High Court under Section 482 CRPC, seeking to quash the complaint, citing bar under IBC moratorium. However, the High Court dismissed the petition, refusing to quash the 138 complaint. There were two issues that were framed by the Supreme Court. First, that does the moratorium under Section 14 of IBC protect the director of corporate debtor when the cause of action under 138 Act arises after the insolvency commencement? And second, did the cause of action to file a criminal complaint under 138 of an Act against the director crystallize after the moratorium was imposed, making 138 Act proceedings susceptible to question? So since the proceedings were filed 138 Act after the moratorium already had come into effect, so what will be the effect of such a complaint then? Now, the relevant observations of the Supreme Court judgment specifically observes that the bare reading of Section 17 of IBC, it shows that the appellant did not have the capacity to fulfill the demand raised by the respondent by way of the notice issued under Clause C of Proviso to Section 189. Because under Section 17 IBC, IRP takes control of the management of the corporate debtor. So when the notice was issued to the appellant, he was not in charge of the corporate debtor, as he was suspended from his position as the director of the corporate debtor as soon as IRP was appointed on 25th July 2018. Therefore, the powers vested with the board of directors were to be exercised by the IRP in accordance with the provisions of IBC. All the bank accounts of the corporate debtor were operating under the instructions of the IRP. Hence, it was not possible for the appellant to repay the amount in light of Section 17 of IBC. Additionally, we have been informed on behalf of the appellant that after the imposition of the moratorium, the IRP had made a public announcement inviting the claims from the creditors of the corporate debtor. The respondent has filed a claim with the IRP. So here, even the complainant in the NI Act has also filed a claim before the IRP. That the complaint under 139 Act against a suspended director of corporate debtor could not be sustained when the demand notice was issued after the imposition of moratorium under Section 14 of the Code. The court distinguished the facts from precedent in P. Mohan Raj, and holding that since the cause of action arose post-moratorium and the director no longer had control over the corporate debtor due to Section 17 of IBC, he could not be held liable. Accordingly, the court quashed the criminal proceedings and reaffirmed that directors cannot be prosecuted for check dishonor in such circumstances where they lack the legal capacity to discharge the liability of the check. Here there is a critical view here coming from me that the Supreme Court has actually not dealt with the issue that if the check issued by the director pertained to the bank account of corporate debtor or was it his own personal account. Because had it been his own personal account, then perhaps then in such cases he definitely had the capacity to honor the check even after the legal notice was issued, irrespective of moratorium. But in the facts, it's not coming forthright whether the check pertained to the corporate or was it the director's own personal check. Anything to discuss on this? This is also a 138 complaint. So
yeah, but actually these two matters clarify the interface between NI Act and the IBC. So, and it's pretty reasonable actually, both taken together.
Fourth Supreme Court case. Sarang Anil Kumar Agarwal versus Bhavesh Dheeraj Lal Seth. here in this case, the appellant, who is a real estate developer, he was directed by the NCDRC to complete construction and hand over possession to home buyers, and was penalized for delays and deficiency in services. So this is a case where the matter went before the consumer forum, and the real estate developer was directed by the National Consumer Dispute Resolution Commission to complete the construction and hand over possession to the home buyers. And he was also, compensation was granted for delay in execution of the services. On failing to comply, the home buyers had filed execution proceedings, and the appellant sought a stay, citing financial distress, settlements with some buyers, and ongoing insolvency proceedings. So, meanwhile, SBI had also initiated insolvency proceedings under Section 7 of the Code against the corporate debtor, and under Section 95 of the Code against the appellant, who was the personal guarantor. So, interim moratorium was triggered in this case. The appellant argued that the moratorium barred the NCDRC execution, but the NCDRC rejected this, holding that consumer claims and penalties do not fall within the IBC moratorium. So the NCDRC did not accept the submission made by the director, personal guarantor, that since he is under insolvency, so execution petitions should be stayed. So the issue before the Supreme Court was whether the execution of penalty orders passed by the NCDRC can be stayed under the interim moratorium provisions of IBC. And the relevant provisions here are the definition of excluded debt, which is under subclause 15 of Section 79 of the Code. This is definitely involving the chapter related to personal guarantors. And then there are penalties which have been specified under Section 27 of the Consumer Protection Act. So excluded debt here means liability to pay fine imposed by a court, liability to pay damages for negligence, liability to maintenance, liability in relation to a student loan, and any other debt as prescribed. Now, Supreme Court observations on the issue. So whether NCDRC's execution should be stayed because of the moratorium imposed under the personal guarantors law. The Supreme Court observes that the penalties imposed by NCDRC are regulatory in nature and arise due to non-compliance with consumer protection laws. They are distinct from debt recovery proceedings under the IBC. So, and Section 94, subsection 3 of IBC explicitly limits the scope of the moratorium by carving out exceptions for certain categories of debts. Clause 15 of Section 79 of the Code defines excluded debts to include liabilities arising from fines imposed by courts or tribunals, damages for negligence or breach of obligation, maintenance liabilities, student loans, and other prescribed debts. So it makes reference to excluded debts. And then it further observes that the damages awarded by NCDRC arise from a consumer dispute where the appellant has been held liable for deficiency in services. So that's the difference that they've made out, that it's deficiency in services. Such damages are not in the nature of ordinary contractual debts, but rather serve to compensate consumers for loss suffered and to deter unethical business practices. Courts and tribunals, including NCDRC, exercise their statutory jurisdiction to award such damages, and these are distinct from purely financial debts that may be subject to restructuring under the IBC. Further, the rationale behind excluding such liabilities from the moratorium is rooted in public policy considerations. If damages arising from legal violations, consumer protection claims, or penalties imposed by courts and tribunals were to be shielded under the moratorium, it would create an unfair advantage for errant entities and individuals, allowing them to evade their legal obligations under the guise of insolvency. So ultimately, the Supreme Court has ruled that the interim moratorium under Section 96 of the Code, which applies to personal insolvency proceedings, does not extend to regulatory penalties imposed under Section 27 of the Consumer Protection Act for non-compliance. The Supreme Court has also held that such penalties are not debt within the meaning of IBC, but are punitive regulatory obligations designed to enforce consumer rights. Consequently, insolvency proceedings cannot be used to evade statutory penalties, ensuring that regulatory enforcement actions remain independent and fully enforceable despite ongoing insolvency. Ultimately, this case was relating to consumer protection laws. So, Supreme Court has given primacy to execution of consumer decrees and has further held that moratorium provisions under the personal guarantor laws will not be applicable to execution proceedings in consumer complaints. And the reason they have given is because they are not relating to debt recovery, but they are related to damages awarded by consumer forums for deficiency in services given to the customers. Any question or doubt or any point of discussion that we can have? Perhaps, but these are civil proceedings. That is also one thing, but the Supreme Court has given a special status to consumer disputes, because these are the nature of compensation or damages given to the customer because he has been a victim of deficiency in services. We can take a break for 10-15 minutes and then we can come and resume the remaining 4 cases that we can do now. Is that fine? Anjali is there?
Yes, that's fine. I think.
Fine. So we can take a break for, we can come back by 12:20, I guess.
Are we discussing the BPSL judgment?
Sorry?
Will we be discussing the BPSL judgment?
Which judgment?
BPSL. Bhushan Power?
No. Bhushan
No.
Power is not there.
Okay.
Are we taking a break or something?
Yes,
Hello?
we are on a break. We are on a break till 12:20.
Okay, ji. Okay, ji.
So shall we start? Shall we resume the session? Are the participants here?
Okay, sir.
Yes,
Yes,
please.
yes.
Yes.
Yes, we are here to listen you, sir.
Can you see the slideshow now?
Yes, it is visible.
Right. So before the break, we had covered 4 Supreme Court judgments. Now, the remaining 4 judgments that I am going to deal with now are all NCLAT's judgments. So the 5th case is EPFO versus Jaykumar Pesumal Arlani, the RP of Decent Laminates Limited. In this case, what has happened? It's a January 25 verdict of NCLAT. The CIRP was initiated against the corporate debtor. During the CIRP, the EPFO appellant had initiated proceedings under the EPF Act under Section 7A for pending PF dues and the Provident Fund dues, and the RP appeared but lacked relevant record, which is, of course, most likely everybody goes through this situation. All RPs go through this situation. So, later, the show cause notices were issued under Section 14B and Section 7Q for damages and interest by the EPFO. And the EPFO submitted its claim to the RP after doing the assessment of the EPF dues. But it was rejected as the resolution plan had already been approved by the COC. So EPFO filed an application seeking directions to admit the claim. The NCLT had rejected the plea, noting that the EPFO order was passed after the COC approval. Hence, the claim was rightly not considered. Now, the EPFO filed an appeal against the NCLT order because NCLT had just rejected the application of the NCLT. Now, issues before the NCLT here were whether the moratorium under Section 14 of the IBC, it prohibits EPFO from initiating or continuing assessment proceedings after the CIRP commencement. So once the CIRP commences, once the insolvency commences, whether the EPFO can initiate the assessment proceedings or it can continue with the assessment proceedings under the EPF Act. Second issue was whether can claims based on such assessments be admitted into CIRP. What assessments we are talking about? Only those which are submitted after the initiation of moratorium. And third issue was whether the claims which are filed by the appellants subsequent to the approval of resolution plan by COC could have been admitted in CIRP. So the claims of EPFO filed after the acceptance of resolution plan by the COC, whether it could have been admitted in CIRP or not. Relevant statutory provisions here are IBC Section 14 relating to moratorium, and then EPF Act has Section 7A which relates to determination of monies due from employers. 7Q relates to interest payable by the employer, and 14B it relates to power to recover damages. And then there is Section 33, subsection 5, which talks about liquidation. When a liquidation order is passed, then in such cases, a suit or legal proceedings which are instituted by liquidator, suit of legal proceedings which are instituted by or against the corporate debtor, there is a where they should not be continuing against the corporate debtor after the liquidation order is passed. So now, on these issues, the observations by NCLAT are given in para 23. That in the present case, admittedly, assessment has been completed after initiation of the moratorium. We thus are of the view that once order of liquidation is passed, moratorium under section 14 comes to an end and moratorium under section 33(5), which is differently worded, comes into play. So NCLAT makes an observation that gives an example of liquidation process, that once a liquidation order is passed, the moratorium under 14 comes to an end, but the moratorium under section 33 triggers. Now, under section 33, subsection 5, the expression used are suit or other legal proceedings. Thus, bar is only against suit or legal proceedings, and there is no bar against assessment proceedings to be conducted by statutory authorities, including the EPFO. So, the bar under section 33, when liquidation order is passed, is only against suit or legal proceedings, but not against the assessment proceedings. Thus, after the liquidation, it is open for EPFO to carry on the assessment. Section 33(5) cannot be held. However, it makes a relevant observation start from here. Section 33(5) cannot be held to apply on assessment proceedings. However, while looking to the expression used in section 14(1), assessment proceedings before the EPFO cannot be continued after initiation of CRP. So, in a sense, NCLAT says that after the liquidation order is passed, EPFO can continue with the assessment proceedings. But the moment section 14 triggers, that is when an IRP is appointed, in such cases, assessment proceedings by the EPFO cannot be continued. In view of the aforesaid, we answer questions number 1 and 2 in the following manner. We hold that after initiation of moratorium under section 14, subsection 1, no assessment proceedings can be continued by the EPFO. So, a very relevant observation here, that if after an order of liquidation is passed, section 33, subsection 5 does not prohibit initiation of or continuation of assessment proceedings. No claim on the basis of assessment carried during the moratorium period, which is prohibited under section 14, can be pressed in the CRP. So, an assessment carried during the moratorium period cannot be is not valid, because, and so no claim can be filed in respect of such assessments which are made during the moratorium period. So, NCLAT has made it clear. Further observations in para 25, it is an admitted fact that claims are filed by the appellant subsequent to approval of resolution plan by COC. So, here claims are filed by the EPFO subsequent to approval of resolution plan by the COC. The NCLT has relied on judgment of Supreme Court in RPS Infrastructure versus Mukul Kumar, which judgment squarely applies to the facts of the present case. More so when the claim on the basis of assessment, which has been made subsequent to initiation of moratorium, is read by section 14, subsection 1 of the code. We are of the view that no such claim can be admitted in CRP. So, conclusion here, the NCLT has, in this judgment, upheld that the moratorium under section 14 of the code bars not only enforcement but also assessment proceedings under the EPF Act if initiated during CRP. It held that claims based on assessments or actions taken during the moratorium or after approval of resolution plan cannot be admitted, reinforcing the time-bound framework of IBC and emphasizing that statutory dues must be raised timely within CRP guidelines. So, a very relevant observation here, because we all know how EPFO comes into picture during the CRP process and sometimes also frustrates the resolution plan, because there are judgments like judgment passed in Debt Airways where EPFO dues have been given primacy over the any other dues, even though during the liquidation process. So, in such cases, this is a relevant observation by judgment by NCLT, where NCLT has said that EPFO cannot continue with assessment when an interim moratorium, when a moratorium under section 14 triggers. So, during the CRP, they cannot do assessment proceedings. However, once a liquidation order is passed, then EPFO can continue with the assessment proceedings and file the claim before the liquidator. Any point of discussion or any doubt relating to this case?
No doubt is, sir, if it is a resolution applicant, successful resolution applicant, which is not
Yes.
going under liquidation, then what is the outcome?
If it's a successful resolution applicant who is, can it please come again?
No, you are saying that under liquidation, the assessment can continue and then file the claim with liquidator.
Yes.
Now, in the event that the resolution has been approved by the NCLT, there is no liquidation.
Correct.
Then what is the outcome? There is a
because
protection.
Yes. So because during moratorium, EPFO could not have continued with the assessment. So once the resolution plan is approved, and the EPFO failed to make assessment proceedings before the initiation of moratorium, so the claims filed by the EPFO cannot be adjudicated because the successful resolution applicant, the statute is giving protection to the successful resolution applicant, that he can discharge only such claims which have been filed in the CRP before the RP. So the EPFO will not be able to get anything in such case. Is that understood?
So, no, I understood, because now if the assessments continue and, EPFO, the EPF Act is actually, any dues under EPF Act have a certain criminal penalties.
Correct.
So this puts, the entire CRP or at least the investor in a position where, these can be challenged in under an act which is immune to the IBC provisions. Like,
Correct. But as far as prosecution is concerned, that is only against the ex-management. The new management will definitely not be prosecuted. That section 32A is there. So section 32A of the code specifically gives immunity to the new management as far as the prosecutions are concerned. As far as assessment claims are concerned, since EPFO failed to do assessment proceedings prior to CIRP, so it has to bear the brunt.
Right.
Any other doubts or any other points you want to emphasize? Come across many cases where, especially because of Jet Airways judgment passed by NCLAT, which was later upheld in the SLP before the Supreme Court, EPFO dues have been given primacy over other dues. So, I mean, even there are judgments to that extent that a resolution plan has to satisfy EPFO dues, even prior to any other dues, even of the secured financial creditors, and that they have taken recourse to the liquidation provisions. But then in this case, the point involved was whether continuance of assessment, if the assessment has not been finalized, whether it could have continued during the moratorium period. So for that, NCLAT has answered that they cannot continue with the assessment proceedings during the moratorium. So it's a kind of relief to the corporate debtor to that extent that since EPFO has defaulted in not completing the assessment before the commencement of CIRP, then at least the corporate debtor can rescue from these liabilities. Because we see in many cases, assessments are also based on estimates without really knowing the details of the real beneficiaries, real employees. So it's kind of a breather in such cases where there are no details available. EPFO is also making defaults. So it's a good judgment in that respect. Now, a sixth judgment that we have is NCLT's only Phoenix ARC versus Kuldeep Verma. It's a March 2025 judgment. Here, it's a very interesting issue about liquidation regulations, whether compliance of liquidation regulations only. So here, liquidation of KS Oils Limited had begun on 16th March 2021. And the appellant filed a claim of 793.45 crores. retaining security interest over the Haldia unit, which has, that unit is of 12.84 acres, and relinquishing other securities. So here the applicant, which is Phoenix ARC, being a secured creditor, having being a secured creditor, it had mortgage over the Haldia unit. Now, after the proposed scheme under the Companies Act, it was rejected. NCLT directed the liquidator on 6th January 23 to proceed with liquidation. The applicant, which is Phoenix ARC again, reaffirmed non-relinquishment of Haldia unit. So it did not relinquish its asset to the liquidation estate. And the liquidator handed over 12 acres, but denied claim over 8 acres, stating it was part of the liquidation estate. So Haldia unit was given to the applicant Phoenix ARC for so that he can Phoenix ARC can realize the secured interest on its own, having the charge over the property. Then on 14 July, the liquidator stated that Haldia unit had become part of the liquidation estate under Regulation 21A of the Liquidation Process Regulations due to appellant's non-compliance. Despite objections, a sale notice was issued on 19 July 2023 by the liquidator. Then the appellant Phoenix ARC had filed an MA number 3 of 2023 challenging the sale. No initial bids were received. Later, Haldar Venture Limited emerged as the successful bidder in February 2024. On 16 February 2024, NCLT rejected the appellant's application, Phoenix application, holding that non-compliance with Regulation 21A2 of Liquidation Process Regulations led to Haldia unit becoming part of the liquidation estate. Now, the appellant filed appeal against the NCLT's order before the NCLAT. Now, before the NCLAT here was that did the liquidator correctly include the Haldia unit assets in the liquidation estate under Regulation 21A of the Liquidation Process Regulations due to Phoenix ARC's non-compliance. So, relevant regulation here is Regulation 21, Sub-Regulation 2 of the Liquidation Regulations. It states that where a secured creditor proceeds to realize its security interest, then it has to pay as much towards the amount payable under Clause A and Subclause 1 of Clause B of Subsection 1 of Section 53, which is relating to the CRP costs and the workman dues. So they has to pay the dues of CRP cost, proportional dues, and also the workman dues, proportional, as it would have shared in case it had relinquished the security interest. And this has to be paid within 90 days from the liquidation commencement date. Also, it has to pay within 180 days the excess of realized value of assets, but that is not relevant in this case. Here we are concerned with the requirement of making payment within 90 days from the liquidation commencement date, as mentioned in Clause A of Sub-Regulation 2 of Regulation 21. And then we'll straight away come to Regulation 21, Sub-Regulation 3, where a secured creditor fails to comply with Sub-Regulation 2, the asset which is subject to security interest shall become part of the liquidation estate. So Sub-Regulation 3 is very clear that where there is a non-compliance of Sub-Regulation 2 by the secured creditor, then the asset will be vesting with the liquidation estate. It will become part of the liquidation estate. Now, NCLT observes here that the applicant as a secured creditor was to make payment under Sub-Regulation 2 of Regulation 21A within 90 days from the liquidation commencement date. When obligation is linked with the time period, the appellant cannot fall back on the argument that the liquidator has not communicated the estimated amount to the secured creditor. So even if a contention was raised that the liquidator has not communicated what amount I am supposed to pay, that obligation of 90 days is still there with the secured creditor. So it has to reach out to the liquidator, demand, and then make payment within 90 days. Even if the liquidator also fails to communicate the estimate amount to the creditor. When secured creditor at no point of time even asked for estimated amount from the liquidator and no steps were taken under Regulation 37 by the appellant, it is not open for the appellant to contend that Regulation 21A sub-regulation 2 shall not apply, since he was not communicated the estimated amount by the liquidator. So, in conclusion, the NCLT has upheld the NCLT's decision that the entire Haldia property, including the portion claimed by Phoenix ARC, formed part of the liquidation estate. The NCLT also emphasized that Phoenix ARC's inaction and failure to timely notify its decision under Regulation 21A, Clause 1, pay the requisite amounts under Regulation 21A2 and pursue recovery within the prescribed 180-day window resulted in its loss of security rights. The ruling reinforces that secured creditors must strictly comply with IBBI liquidation regulations, as procedural non-compliance extinguishes their exclusive claims over the secured assets of their own security. So it's a very relevant judgment, given the fact that Regulation 21A is giving a very fixed timeline that within 90 days, a particular amount has to be disbursed by the secured creditor to the liquidator, especially the proportionate costs of the CRP costs, the liquidation costs, as well as other charges. And if they are not paid within 90 days, then liquidator has all rights to inform the secured creditor that now the assets have been relinquished and now they are forming part of the liquidation estate. So this is a very important observations that have come by the NCLT. Any questions, doubts, or point of discussion on this? I hope everybody has understood this judgment.
Yes, yes.
So what I see from my own experience as an insolvency lawyer, these issues are usually not raised by the liquidator. I think whenever these issues arises, because perhaps whenever a secured creditor is not relinquishing his claim and realizing the security interest on his own, in such cases, the requirement of 90 days, I don't know how many liquidators or RPs are actually following this requirement also. And they have to make payment within 90 days. So just an opener for everyone that this requirement is there. So the secured creditor has to make payment within 90 days.
So basically, not only if they're invoking their security interest, they have to.
Yes.
Return
They
it
have
back
to,
within 180 days.
sorry? I think there was some break in the voice.
Residual dues I'll tell you a case. There was one case where there was one asset which was exclusively charged to a particular bank. Okay. And then that bank was also the part of the consortium of
Correct.
other banks where it had first pari passu charge on other fixed assets. So this guy said, I will realize my own security interest and but my charge on other things should also remain. So I told him nothing doing. If you choose to realize your security interest, say your dues are 300 crores and this property is worth, say, 5 crore and you feel you will take it, rest of it will become unsecured. Section 53, 1F, if I'm correct.
Yeah, so for the other assets, he had pari passu charge.
He had pari passu charge. He said, in the other asset, I should remain secured. I said, you will not remain secured.
No, he won't.
So then he left this asset for me to sell.
Correct.
So you need to take a stand, or kya?
Correct. But there is a requirement where they have to make payment of certain charges within 90 days.
They have to pay pari passu charge. The pro rata liquidation cost, whatever which the liquidator says, plus that liquidation cost includes the liquidator's fee.
Correct.
That is where they try to argue ki why I should pay you fee because you are not selling anything. But I am a liquidator. I am not a seller. I am not a commission agent. I have
Correct.
to ultimately complete a whole lot of legal process before I can actually shut down the company.
Correct.
So obviously you have to pay my fee even if you are not doing this. Even if you are selling it yourself.
Correct. No, but
I
that's a
don't know what
requirement
are
under
the
the law.
other. I don't know what other people's experiences are. I put my foot down on all this,
Should be.
and people have
Sometimes.
paid also. People have paid, or they have let me realize their security. So sometimes the bankers or some people try to, have it
Yeah,
both
it's
ways.
correct. Because the IPs also, I mean, they tend to be lenient because these are the prospective persons who are going to choose their liquidator. So,
Yeah, I know.
yeah. So all
No,
that
but you
is
can't
there.
do something which is you
But then
can't
this is
do
a
something
requirement
which
of
is
law.
wrong, no?
And certainly, I mean, if not the liquidator, then at least the other members of the other creditors who are unsecured,
Hmm.
they get a vested right over the
Hmm.
properties to some extent. That
Hmm.
if somebody is having a mortgage and not making the requisite payment within 90 days, then this
Hmm.
asset goes into liquidation estate. Has to be then the bottom line mechanism will come into play, and in such cases,
No, so issue is now that section 53 uh, frankly needs a slight bit of redefinition, because was the legislative intent to actually put all the secured creditors as one? Because there are term lenders who has charge on fixed assets, and then there are working capital lenders who have stocks on, who have financed inventories, who have financed, bills. Now, those securities will disappear because most of the fraud happens because of that only. Either you inflate your uh, stocks or you create sundry debtors. And now, when it comes to liquidation estate, if these so-called working capital lenders will automatically give up their security interest. Now, if the secured creditor who is having term charge on fixed asset also gives up the security interest, and all of them become one, and there is no inter se agreement is not respected at all, which is, in my view, incorrect. Now, recently, so there were two judgments. One was, I think, this Amit Metallics, which was basically for a resolution plan. Resolution plan where there was one lender who was trying to push it into liquidation because they didn't get the liquidation value. Now, in the resolution plan, I feel it works uh, in a different manner, because if there are unsecured financial creditors who are having a good voting share, you have to pay them off, you know, and in the larger interest of corporate revival, one can say that one lender should not be, allowed to, trip the process. But in liquidation, the minimum liquidation value due to you have to come to you, no?
correct.
So if you have a first charge on the asset, ideally you should get the whatever you realize out of that thing.
Definitely. I mean,
So
that is why the mortgage was created. Mortgage or
that is why the mortgage was created.
that is why the mortgage was created.
So so far we have still been following that old practice. I have been following that old practice, but then where I take an undertaking, just in case Supreme Court finally says ki but if I do not uh, then what will why would anyone relinquish the security interest in the first place? The term
Correct.
lenders will definitely not.
They won't. Nobody does.
So in our case, since we do this, because I'm handling liquidations, so everybody has relinquished security interest.
Correct.
Okay, sir. Thank you. That's
Any other
Are we-
doubts, points of discussion on this? Especially the 90-day requirement, it's very stringent. So we have now a judgment also supporting a liquidator stand that within 90 days they have to be paid these charges. Otherwise, the asset will be relinquished. They will be forming part of the liquidation estate. Okay, so we'll move to the next judgment now. Now, this is ED matter. Anil Kohli versus Directorate of Enforcement. So, NCLAT Delhi, 3rd July 2020, very latest pronouncement, passed in July only. So, here in this case, the corporate debtor was involved in manufacturing and exporting basmati rice. And it had availed substantial credit from a consortium of banks led by SBI. Due to continued defaults in repayment, its accounts were declared NPAs. SBI issued a recall notice and a notice under Section 13(2) of the FSC Act. Then the SBI filed application under Section 7 of IBC before NCLT Mumbai bench, which was admitted. CIRP initiated, moratorium under Section 14 imposed, impellant was appointed as IRP. Now, IRP was directed to make public announcement as per Section 15 of Code and Regulation 6 of CIRP regulations. Meanwhile, ED initiated an investigation under PMLA against the associate company of ED, alleging that large export advances to the cooperative debtor were proceeds of crime. So large export advances which were to the corporate debtor were proceeds of crime. And ED registered an ECIR, which is corresponding to FIR, and issued a provisional attachment order under Section 5 of PMLA, attaching corporate debtors' immovable and movable assets. Now, the RP wrote to the ED seeking deattachment of assets, citing moratorium provisions under Section 14 and overriding effect of IBC under Section 238. But ED gave no relief. RP then filed a miscellaneous application under Section 60, subsection 5 of IBC for NCLT, seeking to quash the provisional attachment order and direct ED to recall it during CRP or until moratorium is in effect. Now, NCLT in its order dated 21st May 2018 dismissed the application, holding that ED's provisional attachment order under Section 5 of PMLA was outside the scope of IBC's Section 14 moratorium. So, moratorium is not applicable to attachment proceedings. Then NCLT also held that PMLA is a special penal law with its own adjudication mechanism under Sections 5 to 8 of PMLA and cannot be overridden by IBC unless expressly excluded. PMLA adjudicating authority later confirmed the provisional attachment order through its order dated 11th June 2018. Now, there were three issues before the NCLT here: whether the provisional attachment of assets by the ED under the PMLA violates the moratorium imposed under Section 14 of IBC. Second, whether the IBC by virtue of Section 238 overrides the PMLA in case of inconsistency, particularly in the context of resolution processes involving tainted assets. And whether the NCLT and NCLAT have jurisdiction to interfere with confirmed attachments under the PMLA, that they are actually tribunals can really interfere with the matter. So, the relevant provision here is Section 238, where the IBC has overriding effect over all these statutes we all know. And now answers to these issues by NCLT. For that, PMLA also Section 5 attachment. We all know these provisions, who all are doing ED attachments. Provisional attachment is done by ED by following a particular procedure. And the Section 4 then 5, provisional attachment order is passed. Now, NCLAT observations on the issue. It relies upon the NCLT's previous judgment in Varsana Ispat Limited, and held that if attachment under PMLA is based on prior ECIRs and is duly confirmed under PMLA provisions, then such action cannot be interfered with by the IBC forum merely because CRP is ongoing. So if it's a prior ECIR, then certainly attachment proceedings cannot be interfered with. In the present case, while the PAO, Provisional Attachment Order, was passed a few days after CIRP admission, the ECIR investigation commenced as far back as in 2013. So the ED's proceedings were therefore, that's when IBC was also not enacted. So ED's proceedings were therefore rooted in pre-existing criminal investigation process, and the assets involved were allegedly acquired as proceeds of money laundering, taking them outside the regular asset pool as contemplated under IBC. Further, a conflict may arise when the ED attaches an asset during CIRP, rendering it unavailable for resolution. The appellant contends that such action frustrates the court's purpose of value maximization. While it is true that the IBC thrives on a free and encumbered asset based to attract resolution applicants, if prime assets are rendered unusable due to attachment, the likelihood of resolution reduces. So it shares the concerns, as we all do, that, but however, is not a sufficient ground to invalidate another statute's valid operation, especially when it relates to proceeds of crime. Conclusion: in fact, after analyzing all submissions and considering binding precedents, it held that provisional attachment under PMLA did not violate Section 14 moratorium of IBC, and Section 238 of IBC does not override valid attachments under PMLA. It further held that the adjudicating authority and the appellate authority, they also have no jurisdiction to direct release of such attached properties. So on the jurisdictional aspect also, they said that the NCLT and NPLAT cannot interfere with these. But this is only about provisional attachments. We all know that Bombay High Court as well as Delhi High Court have pronounced section relying on Section 32 or A also, that once resolution plans are approved, then these attachments will go. Any questions? Any point on discussions? Any doubts on this judgment?
No, so are these judgments saying that can a ED after a CIRP has commenced, after a CIRP commenced, attach a new asset? Like they had attached some assets, let's say in a case, and then the CIRP has started in that corporate debtor. Some asset maybe by default, by oversight, they did not attach. Then they come to know that this asset I have, the corporate debtor has.
Which is also prima facie proceeds of crime. It has to be prima facie a proceed of crime first.
So when they write their ECIRs, no?
Right.
I have read through their ECIRs. Those are kind of vague.
Correct.
ECIRs are vague, where they are not really pointing out what they basically say. This much of fraud has happened. Now they are supposed to either bring back the money or attach any asset of equivalent value.
Correct.
So most of the attachment is happening saying that these are of equivalent value, not necessarily it is being said that these are maximum assets are financed by banks. So if it is a factory being attached, the factory would have so these are mortgaged assets, but they take a stand that we can attach any asset of equivalent value.
Right, correct.
So,
there are two aspects to look into this. First, I've also gone through many such cases.
Yes, sir, please.
For example, I've seen cases where prima facie in the provisional attachment orders, the findings are relating to proceeds of crime of value of, let's say, 50 crore rupees. But ED
Yes.
goes on to attach assets of more than 200 crore rupees of the corporate debtor. So, I mean, there is a blatant, say what you said, the word you used was vague. I'm saying they're just not logical at all while attaching certain assets. Because if you are saying that some assets, like the procedure prime which have been generated by the accused persons under the money laundering laws, is somewhere in their investigation coming out to be of a particular value, then why are you attaching assets of value more than 4 times the procedure prime? To some way it is unjustified, especially when CRP is going on. Because there are many stakeholders, including in builders projects, when there are home buyers involved, their hard-earned money.
NCLT somehow interferes in this.
Yeah.
NCLT is not to interfere in PMLA proceedings.
Problem is
PM
that, yes, NCLT and CLAT have no jurisdiction, but high courts have come into rescue.
PMLA authority, if you apply under.
Yeah. Second, once a resolution plan is approved, then the law favors the resolution applicant. Because here we are talking about only assessment proceedings, whether they can be done during moratorium. This was a judgment only dealing on this point. That whether during moratorium attachment order can be passed by ED. And there they have made a clear-cut holding that they have held that they can do that. But once a resolution plan is approved by the NCLT, then such assets automatically go out of the clutches of the ED attachment. Then the resolution applicant, successful resolution applicant will definitely can easily take over the possession of those assets.
No, but then he still has to litigate, He still has to litigate.
No, once a resolution applicant, I think there is clear-cut judgment of Bombay High Court as well as Delhi High Court on this aspect. Even in such cases where a resolution plan is approved, and even in those cases where a liquidation order is passed. Because I believe there is a Delhi High Court judgment of Justice Yashwant Verma only, that where a liquidation order is passed, in such cases also the attachment goes under section 32. And there is a Bombay High Court judgment. I mean, it was widely discussed. I think it's been more than 2 years now, where it says that once the resolution plan is approved, in that case also.
I think this has been appealed in Supreme Court, sir, and it's
Yeah,
pending.
the matter is pending before Supreme Court, but I believe there is no stay. There is no stay on those.
There is no stay, but ED is not releasing also.
We are likely to see a settled law, I think, somewhere in a year or two.
They are not releasing either, because here, like let's say, though 32A and all these things prevails, you have to put the asset first as a liquidator. First, we have to hand over from ED.
Correct.
And then only we are able to sell it. So, without a proper handover from ED, even if you end up selling it, you will not be able to transfer that asset at all. Because everywhere, ED has written to all the, let's say if it is property, when ED attaches, they send a letter to all the sub-registrar offices that so-and-so property cannot be transferred without our NOC. And
correct, but even the liquidator can write to these officers that after this judgment passed by the NCLT, liquidating the asset, liquidating the corporate debtor.
Sir, can I share my experience?
Don't take a call because I'm handling live case.
Hello.
I know. I think, I'm more concerned about CIRP, ongoing CIRPs rather than liquidation, because liquidation, again, you have to sell off the property as a liquidator. But where there are cases, first concern is that these resolution applicants will not turn up because of ED attachments.
Sir, can I
So
share
for
my
them, it is a breather. It is a breather to that extent. They just need to be given the confidence that once the resolution plan is approved, then at least you will get those assets after the court orders are passed.
Sir, can I share my experience?
Yes, indeed.
So, there are two scenarios. One is during the CIRP and one is in the liquidation period.
Correct.
Now, as far as the CIRP is concerned, if there is a change in the management, then section 32A of IBC comes into play. And then it says that it will be a clean slate for the new management, but ED is not agreeing for that. So you have just mentioned that High Court judgment, which is Shiv Charan judgment, which is under appeal before the Supreme Court. Now,
Yes.
finality has not yet achieved in the Shiv Charan judgment, because now ED is being asked, okay, you tell us what is your view. Otherwise, the IBC will become redundant. If this is a view you are to take, this is one situation. Now, Mr. Ray has just said, I'm just coming on that part. In the liquidation period, when there is a ED attachment, now there is a provision in the PMLA Act itself. Now, in the PMLA Act, there is a provision that if there is an attachment, then you file an appeal before the appellate court, which is PMLA appellate authority.
PMLA appellate tribunal.
Yes, yes. So many cases we are handling in PMLAT. Now, there is a new scenario which has come up, that there is a provision under Section 8 that you can go to the trial court. If you go to the trial court and make a request to the trial court for deattachment of those assets, then trial court has the power to do this. Because in one of our cases, we went all across up to the Supreme Court, and then finally ED has come up that since there is a public money involved, because there were mostly public sector banks, so they said that we are okay and willing to release the assets. Now the process is that we have to go to the trial court. Once we go to the trial court, we have to make an application, and after making an application, then trial court has a power to deattach the assets, and then we have to go to the NCLT, and then finally NCLT will give a order to go ahead for the sale of the asset. Now there is a catch here. Now the catch is whether charges are framed or charges are not framed, because law is evolved in such a manner that if charges are framed, and then there is a scenario which will come up that trial court has a power to release or not to release. If charges are not framed, then there is a scenario where trial court may or may not have power to release it. But normally, what we have observed that in most of the cases these days we are handling in Delhi, in most of the cases, the ED comes and gives a consent for that okay, they have no problem and they will relinquish their charges. This is what is the
This is in cases of liquidation or
liquidation.
cases of successful?
Liquidation.
Yeah, this case of liquidation. See, the
Yes.
first such case happened is when in the Nirav Modi cases, okay, which I am handling, Five-Star International, Five-Star Diamond International, PMLA court under Section 8, subsection 8, allowed the release of taking from all the creditors that in the event, and ED was on board, in the event, the judgment ultimately goes against the, in favor of government, that everything has to be proceeds of crime and everything has to be turned over to the government, then the stakeholders, all the banks, will turn it over, whatever they have received. And I, as a liquidator, if there is something remaining in my hand, will also have to surrender it to the court. This is the undertaking that happened. This is the first case where this happened. And now ED is proactively giving its consent, because there is a catch. If Supreme Court holds in favor of Section 32A, in a way, a substantial power goes out of the ED's hand. So the case by case, they are giving the consent. So
that is another thing. Plus, I believe post conviction only there is a confiscation order that can be passed by the trial court.
Precisely,
So,
precisely.
confiscation, before that there cannot be no confiscation, and I believe though ED can take possession post attachment, but they also don't practically, for all practical reasons that they have to monitor it, they don't take possession of these properties, like physical
they
possession.
do.
Sometimes they don't. What I've seen is because of practical, because I've seen
I have taken over many such properties, but they don't maintain them. Because I am as a liquidator, I have taken possession.
Yeah, so that's what I'm saying. You have taken possession because ED possession was not there.
They don't maintain them. They just do. They just lock it up. They lock it up and they
on paper.
Yes. No, not only that, they actually seal the premises.
Oh, they seal. In some
They
cases,
seal the premises. Yeah, they seal the premises. Unless it's a running factory or something like that where workers are working and this thing is there, then they will not seal. Okay. But otherwise, they seal the property.
Now there is a
So the
very
property,
there is a
yeah, please continue.
there is another interesting thing which we have been arguing in the Supreme Court, especially in these matters only, because we were saying that Section 32A comes into play, and Section 32A says that if there is a change in the management, then it is a clean slate, this, that, all those things we were arguing. Now there is an interesting thing which is given in the Section 32A itself. Now, Section 32A, subsection 2 talks of it. I'll just read it out for the benefit of all of us. And in fact, this is a very interesting thing. It says no action shall be taken against the property of a CD in relation to an offense. So it is criminal. PMLA is a criminal committed prior to commencement of CIRP, where such property is covered under the resolution plan approved by the adjudicating authority under Section 31. This is what it says, comma, which results in change in control of CD to a person, or it talks of liquidation, sale of liquidation asset under provision of Chapter 3, Part 2 of this code to a person. Now, this is important. To a person who was not one, a promoter or in the management or control of corporate debtor or related party of such person. This is one. Or it says further, a person. This is important. This is Roman 2. A person with regard to whom the relevant investigating authority on the basis of material in its possession, reason to believe that he had abetted or conspired for commission of offense and has submitted or filed a report or a complaint to the relevant statutory authority or the court. Now here the question comes, who will decide on it? So according to us, the answer is that it is the PMLA court who will decide on it. Once PMLA court decides on it, then this can be taken forward. But the problem is this is the IBC law. This is not the PMLA. So in IBC law, the authority is NCLT. Now NCLT has to decide. So this question is still open. It is still not concluded. It is not concluded and it is not final yet. So therefore, Section 32A interpretation qua the PMLA, qua this ED issue, still open in my view. It needs to be decided. It is not closed yet.
Maybe I think one of the I hope it culminates into deciding all the issues rather than so that's the law is settled properly. Wait for that.
Hello, Apoorv, one
Ji,
doubt. One doubt I want to raise. I'm IP and a lawyer as well, little. This basis of this judgment seems that that this ECIR was in process, is in activation before IBC or
Right.
before CIRP, correct? But what would be the scenario, when after IBC, after CIRP, after moratorium, something comes to the knowledge of ED and ECIR process starts, and then will that IBC will prevail, or still those PMLA would have?
See, as on date, provisional attachments are not being interfered by IBC even when the ECIR is of a later date after the commencement of insolvency.
So
because moratorium is not there on the provisional attachment. But again, we are saying once the resolution plan is approved by the NCLT, then 32A comes into picture. 32A will give, because then the corporate debtor, the successful resolution applicant becomes the corporate debtor. And so the corporate debtors' offenses and corporate debtors' assets involved in those offenses, they will get a clean slate. That's what Mr. Sandeep was also talking about. So, so that is the benefit that we have. But of course, I mean, that's the fight. Once the attachment is there to get a successful resolution
the way some of the cities manage their affairs, sometimes it is difficult to even after resolution gets finalized, a few facts, and then once those facts come to the picture at a later date of some funds parked abroad or somewhere, the linkage is being given to those anti-money laundering or AML, So then there's no end to it, right? There has to be some finality somewhere.
There is
on
no
the
end to
process.
it, plus with the uncertainty with these, because see, ultimately PMLA proceedings are linked to the main predicate offense, the scheduled offense under the PMLA Act. Now the
Yeah, so
scheduled offense, for instance, the court trying
supposedly,
the scheduled offense. I'm
yeah,
sorry, just let me complete. The court
yeah,
trying the scheduled offense. Let us say it comes to the conclusion that there is no commission of the scheduled offense.
yeah.
Everything goes.
Yeah, yeah, yeah. I mean, supposingly, regulation plan is finalized, applicant has come over, business has moved on, taken over, and after that, some fact came to know that somewhere in the other part of the world, some accounts were there, which were, et cetera, et cetera. And then, again, will that thing will start retrospectively? What will happen to the entire process? And all those questions comes in the play. I mean, Jindal Steel, Bhushan Steel is one case, which still struggling with the retrospective effects. But in this case, what would be scenarios? So there's somewhere it has to be end to it, right? That's what I'm
There should be,
trying to understand.
law should be settled. The law should be settled so that there is clarity for all the professionals who are dealing with IBC, that where are those assets going to go ultimately,
Correct.
who are under
Correct.
ED attack. That is true.
Correct.
Any other questions?
Okay, thank you. Thank
Any
you.
other points of discussion? I think Sandeep ji has raised some valid points. I think perhaps a new ways has been thrown upon, where the criminal court, which is trying the PMLA offences, under Section 8 of the PMLA, the applications are being filed. But in such cases where charges have been framed, I'm sorry, in such cases, it depends. If the charges have been framed, then the court might have a different perspective. And if the charges are not framed, perhaps in such cases, the most relevant point is that the ED is not opposing such applications.
In both
So-
cases, if ED opposes, the PMLA court does not release.
Yeah, but if ED does not oppose, then it does.
So basically, everywhere, I have also filed a few cases like this. So then, before I file for the property, I talk to ED, and I said, "Sir, ये लगा रहा हूँ, आप आपका एडवोकेट को बोल देना कि सेम टर्म्स एंड कंडीशन में अप्रूव कर दे." In a case where already some assets have been released, so some new assets have come into picture, and that's how.
I think I'm not able to hear.
Yeah. So what I am saying, sir, ki right now my network is a little problematic here.
Right.
The what I am trying to say, sir, ki without the ED NOC na, the PMLA court is not really releasing anything. At least
That
in
is true. See, I
at
tell you what,
least
why
in Bombay.
again, because
At least in Bombay.
PMLA Appellate Tribunal is actually the real authority who's before whom the provisional attachment orders are challenged. So,
Sir,
to be really frank,
ED
criminal court really does not come into picture. Now, this new.
No, I'll tell you where it comes, sir. I'll tell you what has happened. So in the Nirav Modi case, no, sir, rather the Gitanjali case. In the Gitanjali case and in the Nirav Modi case, particularly Nirav Modi case, the appellate tribunal actually set aside the provisional attachments. ED went on to file a appeal in High Court. ED filed an appeal in High Court. They still didn't release the assets. Only after maybe some not maybe some policy change at the Delhi level. Now they're releasing some of the properties, and that too they're only releasing through the PMLA special court, which is attached the thing. So it's nothing to do with the pure play of law. It's more to do with the executive
Policy,
intention,
executive decision making.
डिसीजन मेकिंग कि किसका एसेट छोड़ना है किसका एसेट नहीं छोड़ना है.
And again, that's what I was discussing with Yogeshji also. Ultimately, if the scheduled offense, the court trying the scheduled offense says that the scheduled offense is not committed, everything goes.
Correct.
So, I mean, all this fight for what? When ultimately, and in such cases, criminal offenses, we see, the low rate of convictions in all types of predicate offenses. So in such cases, I don't know. We are fighting for nothing. It's only
Sir, the
fighting for.
money that was to be siphoned off has already been siphoned off abroad.
It's already been siphoned. It's actually not proceeds of crime in many cases.
And the assets which are left in India are the ones which are financed by banks.
I tell you again, that's why I'm saying siphon off is different thing. But when the criminal court finds out that no offense is committed, which would invite PMLA prosecution, then what's the point of holding assets, attaching those assets? The whole point. But we are in that vicious circle that during investigation, because we are yet to reach the final conclusion from the criminal court, when it comes to the decision whether an offense is committed or not committed, till then this whole fight goes on between IBC and the PMLA and attachment, because every investigating authority has to justify its own existence.
Right.
That why do they exist under the PMLA? That's the whole point.
That's why probably now in cases they are deciding ki, okay, let us monetize the asset, but take an undertaking, since most of the stakeholders are banks only, take an undertaking from the banks that we will return back the money if it is confiscated. Now, interesting question has arisen in my case. So I am trying to, in Nirav Modi case, I am trying to take this thing, direction from the court. Now, as you know, the PF and gratuity, as far as the Jet Airways this thing is concerned, it has to be paid in full, right?
Correct.
Now, out of the proceeds of realization from the sale, if I land up paying the PF and gratuity to the workman, how can that be recovered if at all this thing is concerned? If this is said that it has to be confiscated. And can a offense committed by a promoter of a company, and let's say the company is accused, deprive a workman and employee of their gratuity entitlement and PF entitlement?
Correct.
Now, this is a question which needs to be answered. Now, I don't know who will answer it. We are trying to approach filing one in the PMLA court.
I'm saying not just workmen, but even other, I'm saying cases of home buyers. They are all financial creditors who are unsecured financial creditors. All they are equally, their hard-earned money is involved in the
Absolutely.
projects.
Absolutely. Because since Supreme Court very clearly said that the PF and gratuity entirely has to be paid, with all the sections, whatever penalty and whatever they are approving, whatever claim they are doing, it has to be paid. It becomes little dicey now. If I have realized some money which I have to pay, and there is an undertaking that if it is confiscated, finally people will return back. I can't take such an undertaking from the PF department or from the workers and employees. So
Especially when Jet Airways is there, where you have to follow it, you have to release those.
No, but I'm stuck. How do I do it? Who will give me this undertaking?
Correct.
So I have simply kept the money aside and not paid anyone and trying to take a clarification. Baba, kya karo?
You have no other option.
I have also requested PF department, you please file under section 8 and 8 in PMLA court saying ki bas ye I am not going to give any undertaking, ye paisa mere ko do. But they being PF department, they have not filed anything yet.
Situation will linger.
So
only the professionals are most concerned because they are
we will be hit either way, na? We will be hit either way, na? If we do,
professionals are going to face the music in any case. They are stuck.
So that's fine. Anyways, so next judgment, this is the last one. NCLAT. GV Mary vs Union Bank of India, April 2025, and this is NCLAT Chennai bench. So here the appellant was a personal guarantor to a corporate debtor, and the appellant had filed an application for bankruptcy under section 122 of IBC. So this is a bankruptcy case. Adjudicant authority, while admitting the application for bankruptcy against the appellant, passed an order under section 126 declaring her as bankrupt and ordered for subsequent actions to be taken as per the code. The NCLT further observed that penalty imposed by SEBI, being pecuniary in nature, would come within the meaning of fine and would be treated as excluded debt under section 79(15)(a) and thus outside the scope of bankruptcy proceedings. So the issue before the NCLT was whether the penalty imposed by SEBI qualifies as a fine under section 79(15)(a) of IBC, thereby constituting an excluded debt and remaining beyond the purview of bankruptcy proceedings. Now, relevant observation of NCLAT, the NCLT relied upon Supreme Court judgment in Sarang Anil Kumar Agarwal. We've already discussed this judgment in these slides only. And it's extracted para 32 of the judgment states that the respondents have rightly contended that section 94(3) of IBC explicitly limits the scope of moratorium by carving out exceptions for certain categories of debts. Section 79(15) of IBC defines excluded debts to include liabilities arising from fines imposed by courts or tribunals, damages for negligence or breach of obligation, maintenance liabilities, student loans, and other prescribed debts. This classification is based on the nature of such obligations, which are either statutory, penal, or personal in nature, and therefore they do not form part of the insolvency estate that can be discharged under the resolution process. So the apex court in the said judgment has explicitly held that penalties imposed by NCDRC are regulatory in nature and arise due to non-compliance with consumer protection laws, and hence the moratorium under section 96 of IBC does not extend to them. The penalty imposed by SEBI will be similar. So NCLAT makes an observation that, just taking cue from the Supreme Court observation, where NCDRC's awards have been held to be not forming part of the moratorium. So here SEBI's penalties imposed by SEBI, they are also on similar footing, being of regulatory nature, and hence will have to come with section 79(15) of the code. Hence, the observation made in para 16 of the impugned order is in the light of statutory provisions contemplated under section 79, subsection 15(a) of the code. Treatment of penalty imposed by SEBI as exclusive debt cannot be said to be illegal in any manner whatsoever. So SEBI's penalties are also part of excluded debt. And in conclusion, the NCLAT affirms that personal bankruptcy proceedings under 122 of IBC cannot include penalties imposed by SEBI. The code upheld the definition of excluded debt under section 79(15)(a) of the code to explicitly cover fines and penalties imposed by courts or tribunals, including regulatory bodies like SEBI, as not dischargeable in bankruptcy. By drawing on Supreme Court's decision in the Saranga Anil Kumar Agarwal, it reinforced that regulatory penalties enjoy a separate statutory standing and remain enforceable independently of insolvency or bankruptcy proceedings. So similar to the case of consumer protection, here it's just the difference is that there the court is NCLT, and the issue here relates to penalty proceedings, penalty imposed by SEBI. So any questions or doubts in this?
So here, let's say there is a bankruptcy proceeding,
Yes.
and the bankrupt is entitled to a discharge after 1 year, right? There was one case also recently where the bankrupt was given a discharge by the court, though the RP had this. Now, if all these penalties still hang on his head, what is the validity or what is the value of this discharge?
Definitely, you're absolutely right. Because I believe under the IBC, it talks about moratorium or whatever applicable to all kinds of debts. It doesn't specify the term excluded debts. Excluded debts is used only for the purpose of filing of an application of bankruptcy or for personal insolvency. The term excluded debts is not used for the purpose of applicability or non-applicability or moratorium provisions related to insolvency, personal insolvency resolution. But here the courts are taking definition of excluded debt and applying it. So I believe there might be a clarification later on by judicial pronouncements of this.
No, this has to come from the Act.
Yes, correct.
See, this is not judiciary's this thing. Judiciary is playing havoc with various interpretations as usual, you know. But this will have to come from the Parliament. What was their intention? Because the way the personal insolvency and bankruptcy, this thing was drafted and is enacted, it looks like it was intended to give a clean slate to defaulters, right?
Yes.
You get a second chance in life. Now, if you still have to carry a lot of these problems, you know, then where is your second chance in life?
Right.
So I think it is up to the Parliament who has to. Definitely, the regulatory penalties should fall part of this.
Should fall part, otherwise if he is able to pay, then why is he getting bankrupt? Simple as that.
Precisely. Precisely. Why is he getting bankrupt?
Why is he getting correct?
So,
Any other points? This was our last case for discussion. So this is the conclusion of my own PPT. Of course, we're sharing these PPT with the ICSI. They will share it with all of you. And I hope there is no other point of discussion now.
no, thank you. Thank you from my side. Thank you.
I think, Apoorv, you made a very nice presentation and nice, you brought in some nice cases as well. And some of the points raised were very valid, very, very illuminating. So thank you very much.
Sir. Thank you very much.
And I am thankful
Thank
to
you.
my associates and interns who worked on this.
Yeah. I think you made some good efforts.
Anyways, yes. All right. Thank you very much, sir. Thanks a lot. It was a good
Thank you.
discussion on many aspects, especially
Thank you, sir. Very
ED
fruitful discussion.
and the relevant one is
thank you very
the
much. Thank you.
competition CCI's judgment, competition commission's judgment. That's quite relevant. And anyone from ICSI? Nobody's there. So anyways, we'll conclude the session so everyone can leave.
When does the next session start?
As we
So
have
there is
to
another
look-
session. Then Anjali will have to come. I think we'll have to wait for her.
I don't know.
All right.
Thank you very much, sir, for such a nice session. The session was very interactive and knowledgeable.
Thank you.
And sir, you are requested to share the material, the judgments you have referred.
I'll send it to you in PDF.
Okay. And the next session will start at 3 p.m.
Okay, sir. We'll be back for lunch.
Shall we log out? and
When
come
is the
back
next
again?
session? The next session. What time is the next session starting?
3, sir.